Okay, everybody, welcome back to Cracking the Code 3rd edition. We are now under the Glossary, under the B section. Let's start out with bail. French, bailer, to deliver. By bail is understood sureties given according to the law to ensure the appearance of a party in court. The persons who become surety are called bail. Sometimes the term is applied with a want of exactness to the security given by a defendant in order to obtain a stay of execution after judgment in civil cases. Bail is either civil or criminal. Bouvier's sixth. One who becomes the surety for the appearance of the defendant in court. Bouvier's eighth. To deliver the defendant to persons who, in the manner prescribed by law, become security for his appearance in court. Bouvier's eighth. Noun. Monetary amount for condition of pretrial release from custody, normally set by a judge at the initial appearance. The purpose of bail is to ensure the appearance of the accused at the subsequent proceedings. If the accused is unable to make bail or otherwise unable to release on his or her own recognizance, he or she is detained in custody. The Eighth Amendment U.S. Constitution provides that excessive bail shall not be required. Black's sixth. The surety or sureties who procure the release of a person under arrest by becoming responsible for his appearance at the time and place designated. Those persons who become sureties for the appearance of the defendant in court. Black 6. See note. Note, if the strawman or trade name, that is to say the defendant, cannot make or pay bail, then the man or woman attached with the strawman or trade name defendant becomes the bail. This is formal legal recognition and acknowledgement that this particular man or woman is the surety for the appearance of the dummy strawman or man, trade name, or defendant or artificial person in court. All right, bailee. Bailee means the person who, by a warehouse receipt, bill of lading, or other document of title, acknowledgement, possession of goods, and contracts to deliver them. UCC 7-1021A. Bailment. A delivery of something of a personal nature by one party to another, to be held according to the purpose or object of the delivery, and to be returned or delivered over when that purpose is accomplished. Bouvier's eighth. Note, a cycle of bailment commences when a mother delivers a baby, something of a personal nature, to the state by signing the birth certificate and registering the surrendering legal title to the biological property, that is to say, the baby's body. See dummy, surety, or parents. Bank. Bank means an organization that is engaged in the business of banking. The term includes savings banks, savings and loan associations, credit unions, and trust companies. UCC 9-102A8. See person. Bank acceptance. Draft drawn on and accepted by bank. Bouvier's eighth. Banker. In general sense, person that engages in business of banking. In narrow meaning, a private person who keeps a bank. One who is engaged in the business of banking without being incorporated. One who carries on the business of banking by receiving money on deposit with or without interest, by buying and selling bills of exchange, promissory notes, bonds or stocks or other securities, and by loaning money without being incorporated. Under same statutes, an individual banker, as distinguished from a private banker, is a person who, having complied with the statutory requirements, has received authority from the state to engage in the business of banking, while a private banker is a person engaged in banking without having any special privileges or authority from the state. Black 6. See private bank. Banker's acceptance. A bill of exchange draft payable at maturity that is drawn by a creditor against his or her debtor. Bankers' acceptances are short-term credit instruments most commonly used by persons or firms engaged in international trade. They are comparable to short-term government securities, for example, treasury bills, and may be sold on the open market at a discount. Black 6. A bill of exchange draw on the accepted by a commercial bank. Black 7. See bank, banker, private bank, House Joint Resolution 192 of June 5, 1933. Banker's note. A commercial instrument resembling a banknote in every particular except that it is given by a private banker or unincorporated banking institution. See Black's first. See banker, private bank. Bankruptcy. Popularly defined as insolvency, the inability of a debtor to pay his debt as they become due. Technically, however, it is the legal process under the Federal Bankruptcy Act by which assets of the debtor are liquidated as quickly as possible to pay off his creditors and to discharge the bankrupt, or free him of his debts so he can start anew. In reorganization, on the other hand, liquidation can be avoided and the debtor may continue to function, pay his creditors, and carry on business. Barron's third. Mr. Speaker, we are now here in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization in world history, the U.S. government. It is an established fact that the United States federal government has been dissolved by the Emergency Banking Act of March 9, 1933. Declared by President Roosevelt being bankrupt and insolvent, House Joint Resolution 192, 73rd Congress in session June 5, 1933, joint resolution to suspend the standard gold and abrogate the gold clause, dissolved the sovereign authority of the United States and the official capacities of all United States governmental officers and departments, and is further evidence that the United States federal government exists today in name only. Congressional Record, March 17th, 1993, Volume 33, Chapter 11, Reorganization. Bar. First definition, a partition or railing running across a courtroom intending to separate the general public from the space occupied by the judges, counsel, jury, and others concerned in the trial of a cause, the whole body of attorneys and counselors, or the members of the legal profession collectively, who are figuratively called the bar. They are thus distinguished from the bench, which term denotes the whole body of judges. Black 6th edition. Barratry. In maritime law, an act committed by the master or mariners of a vessel for some unlawful or fraudulent purpose, contrary to their duty to the owners, whereby the latter sustain injury. It may include negligence, if so gross as to evidence fraud. In criminal law, common barratry is the practice of exciting groundless judicial proceedings. Black's first. See note. Note. Both definitions apply equally in the courtroom. In the first, the master is the judge. In some jurisdictions, judges are called masters. The mariners are the attorneys. The vessel is your trade name. The only rightful owner of the vessel is you, and the injury to you, the owner, is the loss of wealth or freedom. In the second, the judges and attorneys proceed against you without the requisite claim to do so, acting on behalf of fictitious entities, that is to say, corporations and governments. Per Erie Railroad versus Tompkins, 1938, 304 U.S. 64-92, the bankruptcy of 1933 had placed everything under the 14th Amendment. Erie's ruling was that there was no more general federal common law, was open admission of anarchy and tyranny. Law and contracts fell under a private colorable law merchant in colorable admiralty maritime, the special federal common law, see special, of the Uniform Commercial Code. Issues are decided in general, see general, equity. So issues are decided in general equity, that is to say conscience of a court, not special equity, that is to say explicit terms of express contracts. Adopting private commercial paper as money resulted in an at-law mixture of public, maritime, bankruptcy, equity, etc. in the same court. The judge moves between one and the other as situations indicates, including shifting from equity into admiralty in order to impose criminal penalties in civil matters. This is why you must post a bond, something normally reserved for civil proceedings. On a misdemeanor traffic citation, a criminal proceeding, even though the matter is actually civil in nature. Arguing the Constitution is frivolous since one has long since consented with what is happening. Bearer. Bearer means the person in possession of an instrument, document, or document of title, or certificated security payable to bearer or endorsed in blank, UCC 1-2015. Bill, commercial transactions. A written statement of the terms of a contract or specification of the items of a contract or of a demand. Also a general name for any item of indebtedness, whether receivable or payable. Black 6th. Also the creditor's written statement of his claim specifying the item, Black's 1st. In mercantile law, the creditor's written statement of his claim specifying the item. It differs from an account stated in this, that a bill is a creditor's statement. An account stated is a statement that has been assented to by both parties, Bouvier's 8th. Bill of exchange. A written order from A to B directing B to pay C a certain amount of money therein named. A bill of exchange is an instrument negotiable in form by which one who is called the drawer requests another called the drawee to pay a specified sum of money. A bill of exchange is an order by one person called the drawer on or maker to another called the drawee or acceptor to pay money to another who by the drawer himself called the payee or his order or to the bearer. If the payee or the bearer transfers a bill by endorsement, he then becomes the endorser, Black's 1st, see note, payee. Note, it has recently been discovered that the IRS has its own bank account, semi-secret, called a Treasury Tax and Loan Account, or TTL. In every banking financial institution that deals in Federal Reserve notes, it has also been verified that the IRS levies are affected from the Special Procedures Function Department or Office via simple fax, bill of exchange, instructing the particular bank, savings and loan, credit union, brokerage house, etc., to debit the depositor's taxpayer's account and credit the TTL, or the Treasury Tax and Loan Account. Bill of lading. In common law, the written evidence for the contract and carriage and delivery of goods sent by sea for a certain freight. Blacks first. Birth, the act of being born or wholly brought into separate existence. Blacks first. See note and note at birth record. Note, a man or woman is not, or a man, okay, here we go. Note, a man or woman is born. Trade names are wholly brought into separate existence. Ooh, interesting. So your flesh and blood is born, but your trade name is wholly brought into a separate existence. Each event qualifies as a birth. The birth certificate documents a muddied mixture of the two events that allows the system to both claim that it is your birth certificate, yet also claim to hold legal title of, yet not ownership of, the corporately colored trade name. Birth certificate, a formal document which certifies as to the date and place of one's birth and a recitation of his or her parentage, as issued by an official in charge of such records. Furnishing of such is often required to prove one's age. Blacks sixth. Note, a birth certificate is a negotiable document. See document. A registered security, see securities. Pedigree chattel, see chattel. Document that establishes the existence of the straw man, see straw man. A distinct artificial person with a fictitious trade name, document of title for the straw man. This is a warehouse receipt for your body, a delivery receipt. For many years, the designator, the U.S. Department of Commerce, the Bureau of Census, appeared on birth certificates. In America, the original birth document is generally created at county level, sometimes at city level, via birth documents from the hospital. The source of the following information is U.S. Vital Statistics System, Major Activities and Developments, 1950 through 1995, published by the U.S. Department of Health and Human Services. Beginning with the 1933 revision, the birth certificate became the standard certificate of live birth. There have been 11 different subsequent issues of this document. The National Office of Vital Statistics had its beginnings in 1935 when the Division of Vital Statistics, then in the Bureau of the Census, was mandated to promote a cooperative system of vital statistics and vital records. From the earliest days of their existence, the American Bar Association and American Medical Association provided strong support for establishing offices to collect vital statistics. From page 47 of the book, it reads, from this time, 1836, forward, the course of registration and vital statistics was to be recognized as basic to the development of public health organization and practice. Part of the motivation of the act was to improve vital records as legal documents for the security of property. Vital records are legal documents for the security of your private property, your true name and trade names, whatever name appears on the documents. The source of the following information is the Model State Vital Statistics Act and Regulations, 1992 revision, U.S. Department of Health and Human Services. Live birth is defined as follows. Live birth means the complete expulsion or extraction from its mother of a product of human conception, irrespective of the duration of pregnancy, which after such expulsion or extraction breathes or shows any other evidence of life, such as beating of the heart, pulsation of the umbilical cord, or definite movement of voluntary muscles. Whether or not the umbilical cord has been cut or the placenta is attached. Heartbeats are to be distinguished from transient cardiac contractions. Respirations are to be distinguished from fleeting respiratory effects or gasps. The National Office of Vital Statistics was established in the Public Health Service in 1946, with the head of the office reporting directly to the Surgeon General, a military commander. This means that collection, maintenance, and dissemination of all vital statistical information are in the hands of the military as dictated over by the Commander-in-Chief. Section 24 of the Act, copies from the System of Vital Statistics, contains the most revelatory passage. A. The State Registrar and other custodians of vital records, authorized by the State Registrar to issue certified copies, shall, upon receipt of an application, issue a certified copy of a vital record in his or her custody, or a part thereof, to the registrant, his or her spouse, child, parents, or guardian, or their respective authorized representatives. Others may be authorized to obtain certified copies when they demonstrate that the record is needed for the determination or protection of his or her personal or property right. The state agency may adopt regulations to further define those who may obtain copies for vital records filed under this Act. Per the Act, all state registrars are merely custodians of property and look after your personal property, that is to say, the true name and the trade names. You are the rightful owner of that property. The so-called custodian can be lawfully commanded by the rightful owner, you, not to give out the property to anyone else. Such an order would put a permanent roadblock in the path of any who would use the name to make money at any level of government. That property could not be touched by anyone other than the state registrar and you might even be able to demand surrender of custodianship of the property and receive it. Note also that the Act uses the non-judicial common law term authorized representative instead of a statutory term. Okay. The American Association of Motor Vehicle Administrators, the American Bar Association, and the National Conference of Commissioners on Uniform State Laws received acknowledgement from the U.S. Department of Health and Human Services for their input in the revision of the Act. Okay, end of data from Model State Vital Statistics Act and Regulations. Per the definition of birth above, the document references both the newborn baby and the strawman trade name. A certified birth certificate may usually be obtained at county or state level, depending on the state in question. Your birth certificate is one kind of security instrument in which your property is reposed. The first known evidence of government placing a dollar value on people, or per head, is contained in the draft of proposed legislation, which is supposed to originate with the legislative branch at the House of Representatives from President Abraham Lincoln on July 14, 1862, contained on page 3285 of Messages and Papers of the President. Quote, fellow citizens of the Senate and House Representatives, herewith is a draft of a bill of bill to compensate any state which may abolish slavery within its limits, the passage of which substantially as presented I respectfully and earnestly recommend. Close quotes. Abraham Lincoln. Quote, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that whenever the President of the United States shall be satisfied that any state shall have lawfully abolished slavery within and throughout such state, either immediately or gradually, it shall be the duty of the President, assisted by the Secretary of Treasury, to prepare and deliver to such states an amount of 6% interest bearing bonds on the United States equal to the aggregate value of said dollars per head of all slaves within such state, as reported by the census of the year 1860. The whole amount for any one state to be delivered at once if the abolition be immediate, or in equal annual installments if it be gradual. Interest to begin running on each bond at the time of its delivery and not before. And be it further enacted that if any state, having received any such bonds, shall at any time afterwards by law reintroduce or tolerate slavery within its limits, contrary to the act of abolishment upon which such bonds shall have been received, said bonds received by said states shall at once be null and void, in whosoever hands they may be, and such state shall refund to the United States all interest which may have been paid on such bonds. A man in Santa Barbara, California, who obtained his original birth record and document from the Department of Commerce some years ago via a Freedom of Information Act request, reported the endorsements of 17 different foreign countries on the document. There may also be other types of birth documents used by the U.S. government and others to obtain loans of credit. Interesting. Here we go. All right, next one. Birth record. Official statistical data concerning dates and places of persons' birth as well as parentage kept by local government officials, black first. Note, under birth certificates, the definite references one's birth, and under birth record, the definition references a person's birth. Ooh. One means flesh and blood, man and woman. Person means artificial entity or juristic person. All right. Blank. See blank endorsement in blank. Blank endorsement. The endorsement of a bill of exchange or promissory note by merely writing the name of the endorser without mentioning any person to whom the bill or note is to be paid, called blank, because a blank or space is left over it for the name of the insertion of the endorsee or of any subsequent holder, otherwise called otherwise called an endorsement in blank. Black's first. Endorser, here we go. He who endorses, that is to say, being the payee or holder, writes his name on the back of a bill of exchange, etc. Black's first. Endorsee. The person to whom a bill of exchange, promissory note, bill of lading, etc. is assigned by endorsement, giving him a right to sue thereon. Black's first. Bona fide purchaser. A bona fide purchaser is a purchaser for the value in good faith and without notice of any adverse claim, who takes delivery of a security in bearer form or of one is registered form issued to him or endorsed to him or in blank. UCC 8-302. One who has purchased property for value without any notice of any defects in the title of the seller. Black sixth. One who pays a valuable consideration, has no notice of outstanding rights of others, and acts in good faith concerning the purchase. Baron's third. See note. Note, when you consummate the redemption process, you are a bona fide purchaser of your birth certificate and trade name. All right, here comes the next one. Bond. A certificate or evidence of a debt on which the issuing company or government body promises to pay the bondholders a specified amount of interest for the specified length of time and to repay the loan on the expiration date. A long-term debt instrument that promises to pay the lender a series of periodic interest payments in addition to returning to the principal at maturity. In every case, a bond represents debt. Its holder is the creditor of the corporation and not a part owner, as is the shareholder, Black 6th. Note: the birth certificate is the bond instrument employed by the government to secure loans. Next one. Booty. The capture of personal property by a public enemy on land, in contradistinction to prize, which is a capture of such property at sea. After booty has been in complete possession of the enemy for 24 hours, it becomes absolutely his without any right of post-limnity. Okay, we'll look at that in a second. In favor of the original owner, particularly when it has passed bona fide into the hands of a neutral. The right to booty belongs to the sovereign, but sometimes the right of the sovereign or of the public is transferred to the soldiers to encourage them. All right. Post-limine. A fiction of the civil law, by which persons or things taken by the enemy were restored to their former status on coming again under the power of the nation to which they formerly belonged. Bouvier's 8th. Note: literally and legally, property taken from you by the IRS or the courts is booty. IRS, quote, soldiers are, quotes, encouraged to capture booty by offering them rights in the booty they captured. It is believed the agent on the particular case takes the taxpayer's first 6 payments in toto and a significant percentage of any lump sum settlement proceeds. It is believed that 1/3 of the booty captured in the Maritime Vice Admiralty Court, for example traffic court, by the judge ends up in the judge's personal retirement fund. This would also explain the dramatic increase in the application of forfeiture laws and seizure laws in America over the last decade. Capacity. Legal capacity is the attribute of a person who can acquire new rights or transfer rights or assume duties according to the mere dictates of his own will, as manifested in juristic acts, without any restraint or hindrance arising from his status or legal condition. All right, let's stop there and we'll start these C's in the next video.